My dear students, let us discuss about the problem of child labor. We all know that every individual enjoy their childhood period. Every man enjoy their childhood period. Child is the future of man. Empowerment of them is empowering the future of man through the resources of the present. Childhood is the most sensitive and the vulnerable phase of human life. They have to be safeguarded from all kinds of social evils. Children require special care and extra protection to grow up fully. They are the most vulnerable group of society because of their physical and emotional dependence on adults for their protection and care. It would be the responsibility of the society and the state to create a conducive atmosphere for our children so that they can become a responsible human being. Child labor. Child labor is a global phenomenon. The term child labor is often defined as work that deprives children of their childhood, the potential, and their dignity, and that is harmful to physical and mental development. International Labour Organization report on child labor use the term child labor to cover all economic activities carried out by the persons less than 15 years of age, regardless of their occupational status. ILO estimates that more than 200 million children worldwide are still in child labor, and a staggering 115 millions at least are subject to worst form of child labor. In the most extreme form, child labor involves children being enslaved, separated from their families, exposed to serious hazards and illness, and left themselves on the street of large city at the very early age. However, when children help their parents and relatives in skill-based family occupation, it is not understood as child labor. In such circumstances, a child is not deprived of his physical and mental growth. India continues to be the stronghold of child labor even after 7 decades of its independence. There are more than 1.26 crore child laborers across the country, which includes millions of children working in hazardous industries. There are also lakhs of children working as domestic servants in almost bonded labor-like conditions. They are exploited by their employers and have to work 10 to 12 hours in an unscheduled manner. They are exploited for gaining maximum profit in the sector like carpet industries, mattress industries, automobile workshops, hotel and restaurants. Causes and the consequence of child labor. It is generally assumed that the nature and extent of poverty in a country determine the number of child labor. However, there are several factors for prevalence of child labor. It is largely associated with unemployment, inequitable distribution of resources, and the economic policy of the government. The cause of child labor cannot be overstated. It impairs both physical and psychological health of child at the critical stage of life. International perspective on child labor. The establishment of United Nations in 1945 by the Community of Peace-Loving Nations of the World has brought a positive change in the world in the field of promotion and the protection of human rights. Adoption of the Universal Declaration of Human Rights 1948 by the United Nations General Assembly is the milestone in the history of human rights movement in the world. The instrument has been treated as the international standard for promotion and protection of human rights, including child rights in the globe. The International Covenant on Economic, Social and Cultural Rights 1966 obligates the state parties to take up special measures for protection and assistance on behalf of children and young persons. Article 10 of the Covenant provides that children and young persons should be protected from economic and social exploitation. Convention on the Rights of Child. The UN General Assembly adopted the Convention on the Rights of Child in 1989 with the objective of promotion and the protection of child rights. It is a comprehensive and a universal legal document for the welfare of world children. The convention is mainly based on four major principles. Number 1, right to survival. Number 2, non-discrimination. Number 3, respect for the views of child. And lastly, best interest of child. The convention defines child as a person who has not attained the age of 18 years. It obligates the state parties to abolish child labor because it is a serious form of violation of child rights. Article 32 of the Convention guarantees the right of child against exploitation. Article 36 of the Convention further states that state parties shall protect child against all forms of exploitation prejudicial to any aspect of child welfare. It is found that the Convention obligates the state parties to initiate step for protection of child from economic exploitation, which includes child labor. India acceded to the Convention on the Rights of Child 1989 on 11 December 1992 to reiterate its commitment to the cause of children. She has an obligation to fulfill the objective of the treaty signed and ratified by her under international law. India has submitted its first country report in 2001 to the Committee on the Rights of Child, constituted under Article 43 of the Convention. The said committee considered the report and met the following recommendations for prohibition of economic exploitation. Ensure the full implementation of the Child Labor Prohibition and Regulation Act 1986, the Bonded Labor System Abolition Act 1976, and the Employment of Manual Scavengers and Construction of Dry Latrines Prohibition Act 1993, amend Child Labor Prohibition and the Regulation Act 1986 so that household enterprises and the government schools and the training centers are no longer exempt from prohibition on employing children. Promote community-based programs for the prevention of child labor. Ratify 120 Convention number 138 concerning minimum age for admission to employment and number 182 concerning prohibition and immediate action for elimination of worst form of child labor. Strengthened its effort to raise awareness of the public at large, especially parents and children, of work hazards to involved and train employers, workers and civil organizations, government officials such as labor inspectors and the law enforcement officials and other relevant professionals. National perspective on child labor. Constitution is the supreme law of the country. All laws derive its authority and validity from the Constitution. The Constitution of India in its preamble promises to follow socialist pattern of governance. The Constitution also guarantees fundamental rights in the Part 3 of the Constitution, which is the cornerstone of the Constitution. Article 23 of the Constitution of India prohibits forced labor by implication. It prohibits child labor as well. Article 24 of the Constitution lays down that no child under the age of 14 years shall be employed in any mine or engage in any hazardous employment, and any contravention of this provision shall be an offence, punishable in accordance with law. It is clear from this provision that child labor is punishable in India. The directive principle of state policy is the guideline given to the government for the formulation of policy. Directive principle of state policy is non-justiciable rights guaranteed to the citizen of India. Article 39 of the Constitution obligates the government to protect child against exploitation and the moral and the material abandonment. In India, effort has been made in the past to regulate child labor and to improve their working condition. The first Indian law to regulate the employment of children and their hours of work was the Factory Act 1881. Some other acts are the Factory Act 1948, the Minimum Wages Act 1948, the Plantation Labor Act 1951, the Mines Act 1952, the Apprentice Act 1961, the Atomic Energy Act 1962, and the Wherry and Sugar Workers Condition and Employment Act 1966, and the Shops and Establishment Act of State Governments. Child Labor Prohibition and the Regulation Act 1986. The Child Labor Prohibition and Regulation Act 1986 is an important law for the welfare of children living in India. The Act prohibits the employment of any person who has not completed the age of 14 years in occupations and the processes set forth in Part A and the Part B of the schedule of the Act. The Act, that means Child Labor Regulation and Prohibition Act 1986, aimed at banning the employment of children who have not attained the age of 14 years in specified occupations and processes, laying down procedures to decide modification to the schedules of banned occupations and the processes, regulating the conditions of work of children in employment where they are not prohibited. The Act is a penal law. Whoever violates the provision of the Act shall be punishable with imprisonment for a maximum period of 2 years. In MC Mehta versus State of Tamil Nadu, the Supreme Court discussed the provision of the Act. The court directed that employers who violated the provision of the Act should pay a fine of rupees 20,000 for each child, and that the amount should be deposited in the Child Labor Rehabilitation and the Welfare Fund. National Policy on Child Labor. The Government of India has formulated the National Policy on Child Labor in 1987 with a view to eradicate the phenomenon of child labor in India. The policy is the landmark effort of the government for ensuring progressive elimination of child labor. It has been made to provide a framework for concrete program of action. The policy comprises of 3 important heads. Number 1, a legislative plan consists of strict and effective enforcement of the provision of Child Labour Prohibition and Regulation Act 1986, the Factory Act 1948, the Mines Act 1952, the Plantation Act 1951, and the other act containing provision relating to employment of children. Number 2, focusing on general programs for benefiting child labor, which consists of national development programs in the area of education, health, nutrition, integrated child development programs, anti-poverty programs utilized for the benefit of child and their family. Number 3, project-based action plan in areas of high concentration of child labor, engaged in wage and quasi-wage employment. It involved launching of projects for the welfare of working children in the area of high concentration of child labor and the withdrawal and the rehabilitation of working children. Conclusion. The pace of human civilization never stops at any point. It is in progression. The future of human civilization depends on children of the world, which never exclude children living in the slum areas, streets, railway stations. The problem of child labor is still a serious threat to national development. Child workers are extremely important human resources of the country. Acknowledging this fact, the Government of India has taken up both legislative and administrative measures for eradication of child labor. However, the country is not in a position to harness fully the human resources of our child as a result of prevalence of child labor. Child labor is also violation of constitutional promise, particularly Article 21A of the Constitution of India, which guarantees free and compulsory education of all children between the age group of 6 to 14 years. The golden means to eradicate and prevent child labor is affording facilities of education. The National Commission for Protection of Child Rights is also of the view that education is the only effective mechanism to prevent child labor in the country. In this connection, it is worthwhile to remember the remark of Swami Vivekananda. If the poor boy cannot come to education, education must go to him.